around with like my sunshine. Not even wearing a scarf.
Unbearable. Unbearable.
It is. You can't go outside. Okay, I'm gonna not record. Okay.
Welcome again to the special meeting of the San Francisco Ethics Commission for December 19th. It is my understanding that items 1, 2, and 3 up until the point where we were recorded, they just were not shown on television. And Mr. White, is it necessary for us to go through them again, or is the audio enough?
The audio is fine. I think you can just state the fact that the deputy director has recorded the audio of the first 3 items, and it's not necessary to go through them again.
All right, turning then to item number, oh no, I've got to call any comment on the minutes, and I will, hearing no public comment, I'll call the question again. All in favor?
Aye.
Approved. Any opposition? Hearing none. The minutes as amended by Commissioner Kopp and myself are approved 4-0. Turning to item number 4 is a discussion and possible action to approve Ethics Commission regular meeting schedule for calendar 2017. This is a new procedure that the executive director has suggested to give, rather than giving these notices just once a month, giving the public awareness of the agreed dates, assuming that all the commissioners agree that the dates that are on the calendars suggested in the attachment, so that one can plan over the 12-month period. Any discussion, Ms. Pelham?
No, as you point out, Chair Rennie, this is not a requirement, but we thought in keeping with the many things that are on the Commission's policy agenda, as well as trying to enhance and engage the public as much as possible, these are dates that conform with the requirements that are in the bylaws for the Commission's meetings, but we thought it would be useful to establish it as a regular calendar item. And, of course, if something over the time needs to change, it would be changed into a special meeting, but this hopefully gives folks the ability to plan a bit, so that was why we brought it forward for your consideration.
I noticed in looking at it that you have taken into account the Christmas period in 2017, so it won't be a special meeting.
That's right.
Assuming we meet on that date, it'll be our regular meeting. And so in any case, any commissioner have any comments or concerns? I'd call for public comment.
Commissioners, Ray Hartz, Director, San Francisco Open Government. I'd like to commend the Executive Director for this action. It is my firm belief, and a lot of the reason I do what I do, is that each and every commission has an obligation not just to put up with public attendance and participation, but to encourage public participation and attendance. And I think putting out the schedule well in advance gives people the dates well in advance, and they can work it into their schedule and ensure that more of the public who might wish to attend the meetings will be able to do so.
Thank you. Any other public comment? Hearing none.
Move we adopt the schedule.
Second. All right. All in favor?
Aye.
Aye. Opposed? Hearing none. The schedule for the commission meeting, regular scheduled meetings for calendar year 2017 is approved 4-0. Turning to item number 5, discussion and possible action on Sunshine Ordinance Task Force referral for enforcement of Ethics Commission complaint number 1617-102, Ray Hartz versus Eric Marr. And there were attachments that were part of the agenda, and Mr. Hartz, do you want to make your presentation?
Chair, if I might, there was an error on my part in terms of the attachments.
Okay.
So the attachment number 2 on this item should be an attachment on item 6.
Right.
So I apologize for that error and for the public's information.
But it's a different, the item number 6 is Nancy Sarieh versus the Sunshine Ordinance Task Force, and that's what the attachment number 2 should relate to.
Exactly, yes.
Thank you.
Attachment 2 relates to item 6, which is the Nancy Sarieh and Sunshine Ordinance Task Force matters.
Thank you. Mr. Hartz?
Before I start, I thought I had 5 minutes. It says 3.
Yeah, that's correct, 5.
Okay. Commissioners Ray Hartz, Director, San Francisco Government. The first 2 pages of the referral or of the packet you have for item number 5 is the referral letter from the task force to this body. And I would like you to pay attention particularly to the second page and the bottom 2 paragraphs. It says, the task force takes this matter very seriously and believes strongly that Supervisor Eric Marr intentionally refused to respond to Mr. Hartz's immediate disclosure request, failed to appear at meetings before the task force or its committees to discuss the issue, and did not provide a written response to the request for over 15 months. Based on the testimony and evidence presented in the hearings, the task force interpretation of the ordinance, and other applicable laws, the task force finds that the failure to respond to the IDR in a timely and complete manner violates Section 6721E and 6725A of the Sunshine Ordinance, and that the lack of policy infers intentional and willful noncompliance with the ordinance. What you see here is a rough thing of what the order of determination includes. They've got a lot more information there. Basically, in March 19th of 15, I put in an IDR when I hadn't received by the deadline either an extension, request for an extension, or a response. I filed the Sunshine complaint on the 24th. SOFT, the Sunshine Ordinance Task Force, had a hearing on May the 5th, or excuse me, May the 3rd. And Supervisor Marr did not send anybody to that meeting. I will also say that I went before the Board of Supervisors on 3 separate occasions, spent 2 hours waiting for general public comment, and put up a listing of all the supervisors who had not responded to this request, because I sent it to 10 out of the 11 supervisors. Of the 5 who had not responded by those times, the first time I went, 2 of them did respond the next day, and I withdrew those complaints. The only 3 that remained were Supervisor Marr, Supervisor Farrell, and London Breed, the President of the Board of Supervisors. On May 9th of 16, which was a year and 2 months later, we had a EOT hearing. Nobody showed up from Supervisor Marr's office at all. Then on the 31st, they sent a memo to Supervisor Marr. And finally, in July, 1 year and 4 months from the original IDR, he sent a request, which you can see, it's about the 5th or 6th page from the back of your packet. And it's on the supervisor's letterhead. And I'd like to call attention to a couple things. One, the fact that, again, it took a year and 4 months to actually send this. And under the Brown Act, if you look at the bottom 2 lines that I've highlighted, the Public Records Act does not permit an agency to delay or obstruct the inspection or copying of public records. Finally, when a written request is denied, it must be denied in writing. And this request, this response you're seeing is the first and only response I got to my original IDR from Supervisor Marr. Now, the last thing I'd like you to look at on this letter is the second. Am I now on my still on 3 minutes? Or
it's still going.
Okay. Is the last paragraph. It says, however, since the date of the complaint, we have implemented appropriate measures to ensure that public records requests do not get lost, given the circumstances of a limited staff and an abundance of legislative duties to attend to. Well, that's kind of a bizarre statement to make when you say, as of the date of the complaint, which was in March of 2015, we changed our procedures, and then you still don't respond until a year and some months later. And during the entire hearing process, I went to all the hearings. had to go to multiple extra hearings because they didn't send anybody, and the people that they did send could not answer the questions of the task force. And when finally the full task force heard the hearing, they said, why have you, after a year plus, have no response to the fact that you didn't respond to this IDR? They still got no response. So basically, it was just I didn't respond. I didn't respond to the complaint. I attend the hearings, and finally, when it became obvious that it was going to go to the Ethics Commission, was that 5 minutes?
Finish the sentence that you were.
Okay. Basically, the facts are that he willfully ignored the law. I made every effort, and I made a concerted effort to go before the Board of Supervisors, so he knew that this was out there, and he still waited a year and 4 months to respond.
Thank you.
Mr. Chair?
Yes.
May I inquire, do we have anyone here from Supervisor Marr's office?
Yes.
Okay. I just wanted to...
Yeah, it's your turn.
Commissioners, my name is Angelina Yu. I'm the legislative aide speaking here today on behalf of Supervisor Marr. Thank you for your time in hearing this matter today. I'm reading on behalf of the supervisor. I have the utmost appreciation for the work of the Sunshine Ordinance Task Force and that of the Ethics Commissioner, and appreciate the opportunity to have this item heard. On June 3rd, my former legislative aide, Victor Lim, had presented before the Sunshine Ordinance Task Force that my office had failed to respond to an IDR brought forth by Mr. Hartz, and that we had no records responsive to the requests, explaining the unfortunate administrative oversight and missteps that led to the failure to respond to this IDR in a timely manner. Due to a scheduling issue, a representative from my office was unable to attend the follow-up committee meeting scheduled in which this item was agendized for discussion on May 9th, 2016 at the Education Outreach and Training Committee. Since that time, I and my staff have learned from the task force's suggestions and took immediate corrective actions to ensure that my office was and is accessible and responsive, and that I or knowledgeable representative from my office would attend the Sunshine Ordinance Task Force hearings as required. And since a representative has attended all following Sunshine Task Force meetings. On July 26, I had attended the EOTC meeting as a knowledgeable representative to provide a response and an overview of requested improvements that have been made to uphold a systematic way of reading, responding, flagging, and following through to all IDRs that are received, and an official response was provided to Mr. Hartz indicating that we had no records responsive to his request. Through the September 7th, 2016 hearing, because Supervisor Marr was not available, his legislative aides were present to speak to the steps that were taken in response to this complaint. I greatly respect the integrity, role, and work of the Sunshine Task Force and recognize the great importance of strengthening procedures for ensuring that we do respond to immediate disclosure requests from the public. I've strived to comply with the spirit and intent of the Sunshine Ordinance throughout my term, and while the sequence of events for this immediate disclosure request has demonstrated a procedural mishandling and the need for improvement, there has not been a willful intent to violate the ordinance, nor to willfully fail to discharge the duties. I respectfully ask the Commission to find that there has not been a willful violation. Thank you.
Excuse me,
May I ask
Mr.
you a
Chairman.
question?
Go ahead.
What reason, if any, was there when the request was made back in 2015, and then there were meetings of the Sunshine Task Force that nobody showed up? I mean, what's the administrative failure that occurred?
Yeah. At the time, the emails perhaps were overlooked when they came through the inbox. The staffing at the time was structured so that different aides were responsible for different portions depending on when an email came through. So admittedly, there wasn't the appropriate mechanism and checkpoint to make sure that we were able to catch and flag those IDRs so that they were able to be responded to. So we have since made actions to make sure that we are catching those emails.
Commissioner Kopp.
How long have you worked in this office?
I started in May.
Okay. And there are how many others? 2 others?
Yes.
Okay. And what happens when a request for public records arrives at the office? Who is responsible for it?
I'm sorry, can you repeat the last portion of the question?
Who is responsible for responding to a request for public records?
Depending on the subject matter, after an aid...
Give me examples of a subject matter.
For example, if it pertains to something around housing and or land use issues, we have the aide who typically handles those meetings and or discussion matters, take on the initial response of whether or not we have any records pertinent to this request. If they are pertinent to issues around open space, parks, it's a different aid. And so, first of all, we look at the subject.
Let me stop you, because that answers the question I have in my mind. Who opens the letter, the envelope, or receives the email with the request?
If they're coming through electronic email to Supervisor Marr's inbox, it could be the supervisor himself and or the aides, but usually the aides are responsible for monitoring the emails.
One aide or all 3?
We split them up by time of day, but currently I am the one responsible for maintaining the emails.
You did split them by time of day?
At the time the initial immediate disclosure response came through, yes.
So that someone would be responsible for 2 hours, for example, and someone else for another 2?
Hypothetically, half the day, from 12 to 12 and the other half of the day.
Mm-hmm. And were these procedures reduced to writing?
They, as in like in the job description, or?
Not in the job description. In what the responsibilities of the legislative aides were.
The responsibilities of the aides are discussed when we have staff members, for example, when I joined the office, to discuss who would be taking on what work roles.
So this was just done orally, wasn't put on a memorandum that was on a bulletin board or in a central place?
We had kind of charted it out just on notepads so that we knew the times of day that folks were responsible for.
You targeted, you said?
Sorry, charted it out.
Charted it out.
Correct.
What does that mean?
In a staff meeting, we had literally notepads and charted out so that I, for example, would remember the times of day that we are responsible for looking through emails.
And what happened to the chart?
This was in a staff meeting, so we had just jotted it down.
So each of you took notes?
In our staff meetings, we take notes down when we discuss things, but in particular, this was a time when, prior to my joining of staff, so I'm not sure if there were written procedures at that time.
Well, I'm talking about after May of 2016, and with all my questions. Yeah. Was there a memorandum or other document posted anywhere in the office as to who would perform responsibilities on Public Records Act requests?
No, not specifically documented memo.
And do you know if any of the 3 legislative aides will be so employed after January 8, 2017?
I can't speak on their behalf. I think folks are figuring out their next steps.
Huh?
I think everyone's figuring out their next steps.
Meaning that none of the 3 legislative aides are presently destined for continued engagement after January 8th. Is that right?
Supervisor Eric Marr is wrapping up his term at the end of...
No, I'm asking you, do any of the 3 legislative aides expect to be retained by the next supervisor?
We do, for a transition period.
How long is that?
It's undetermined at this moment.
Okay, thanks.
Any other questions, Commissioners, has of this witness? Yeah. Go ahead. Commissioner Keene.
After the Sunshine Ordinance Task Force made the finding that Supervisor Marr had indeed violated the Sunshine Ordinance by not responding, is that when your office first became aware of it? I'm trying to get the sequence here. Was that when you're saying your office first really became aware of it and started reacting to it?
My former colleague Victor Lim had appeared before the task force. I believe it was May 9th of 2015, and had provided a response that he became aware of the IDR when we had received, I think, a memo from the task force alerting us that we had failed to respond to the IDR.
And did your colleague explain to the task force the things that you've said, that it was the aides didn't pick up on it and you weren't aware of it, and that was why there was no response?
He did. He kind of explained the missteps that had happened for that email not getting flagged appropriately for a response.
I know this may not be proper for you to opine on, but is it your impression then that in regard to the task force then coming out with this finding that Supervisor Marr's office did willfully fail to respond, that the task force did not believe him?
There wasn't willful intent from the part.
I understand, but obviously what we've got Supervisor Marr's office putting forth this explanation and excuse that, look, it just fell through the cracks. We didn't willfully do it, and the task force votes virtually, or maybe unanimously, that it was indeed a willful failure. Would that indicate to you that the task force didn't believe him?
I think the task force decision, and I respect their processing of the case before them. But I think from our perspective, from our office, as soon as we recognized that we needed to respond to this IDR, and we were trying to backtrack and figure out how this IDR did, as you say, fall through the cracks, we were focused very much on making sure we took the corrective steps in cleaning up how our staff are administering it, and really focused on moving forward, how are we able to make sure we respond adequately and in a timely fashion to all IDRs. And so we had been very much focused on developing that protocol and that system in response, and we were also finally able to respond to Mr. Hartz through the July task force committee meeting.
Okay, let me that last thing. So at the task force meeting where they found that this was a willful violation, you just said that at that meeting you were unable to respond to the charges, the allegations. Is that what you're saying?
We were provided an opportunity to speak on the position of the office, so we did have that opportunity. But I think part of perhaps the willful violation was attributed to staff absence from the meeting. My colleague, due to a scheduling issue, was unable to make the initial meeting. However, as soon as Supervisor Marr was made aware of the absence, we have since implemented measures to make sure that we've had an aide, if not multiple aides, at the meetings to be able to speak to the commission.
Forgive me if I'm...
Doesn't answer the question.
No. What I'm trying to get at here is what it was that the task force had before them at the time they made this finding that Supervisor Marr had willfully failed to comply with the Sunshine Ordinance Task Force and Sunshine Ordinance. That's a pretty serious finding in regard to a supervisor just blowing off the Sunshine Ordinance, I think you'd agree with that if that were the case. I'm not asking you to admit that you believe that that's the case, but if a supervisor were to just say, well, I don't care about Sunshine Ordinance, I'm not going to respond, that would be pretty serious if a supervisor were to do that, right?
If a supervisor were to, I agree, it is a serious issue. By no means did Supervisor Marr mean to blow off the commission. We do hold immediate disclosure requests and public records requests in the highest regard. And in the time since, through our staff meetings, we do regular check-ins. Are there immediate disclosure requests?
I'm getting you in terms of what you put down and what you put before us, that as of now, or as of sometime after this, you said mea culpa, and you've instituted all sorts of things that will make sure it won't happen again.
Right.
Forget about that. I'm not interested in anything from that. What I'm trying to find out is the history of this thing and how it was that Supervisor Marr and his staff responded to them, to the Sunshine Ordinance Task Force, about why it was that there was no response. And I'm having difficulty, you may not know because you've only been here since May, I'm having difficulty getting that history in my mind so I can make some determination here. So let me just say this. Do you know whether or not at the hearing before the Sunshine Ordinance Task Force, if you don't know, that's fine, just tell me. Do you know whether or not the Sunshine Ordinance Task Force was told on behalf of Supervisor Maher all of the things that you originally told us about? It was just something that fell through the cracks. No one picked up on it. Were they told that at the hearing? If you don't know, that's okay. But
yeah, I don't know for a fact. However, through listening to audio recordings of the previous task force to prepare for this, I believe that was previously discussed by my colleague, but I don't know for certain.
Well, if it's recorded, it would be on it.
yeah, okay. So there's a recording of that?
Of the Sunshine Task Force hearings, I believe so.
Okay. What I'm going to do at some point, rather than make a decision now, I'd like to hear what it was that was put forth before the Sunshine Ordinance, if anything, as to the reasons why this was not responded to before we go forward. If they didn't put anything forth, or if they were putting forth something that was unbelievable, I think that would be helpful to me in making some sort of decision here. But we really don't know. All we know is that they voted unanimously that there was a willful violation. Based upon the presentation, I don't know what they had before them, if anything, from Supervisor Marr's office. And if they had the full facts before them from Supervisor, if they had the full account before them from Supervisor Marr's office that you've told us that you believe the way it happened, then it would appear that they just didn't believe Supervisor Marr. And I think that would be interesting to me to find that out. Yeah, as to
Supervisor. I don't know whether you can respond to it or whether Mr. Hartz can tell me whether my history of this matter is correct. But the original request was in March of 2015.
Correct.
And there was a task force hearing in June of 2015 where Mr. Lim showed up.
Correct.
But the task force made a preliminary finding of violation. But then in May of 2016, they took up this matter again, and Mr. Hartz made a presentation, and at that meeting, according to the order of determination, the task force sent a letter to Supervisor Marr outlining a number of bullet points and asking him to provide certain documents. Were those documents ever provided?
Yes, they were sent to the commission.
When?
They were provided through, I believe, the July 26 hearing to be brought forth at the Education, Outreach, and Training Committee. And this was a request for a log of IDRs as well as the office procedures that are taken in response to IDRs.
And those were provided.
Correct.
In the letter of July 26th, it says, upon a review of our files, we did not find any relevant documents. That's not referring to the documents that the task force was asking for in June 2016 or May of 2016?
Yeah. To clarify, the statement about not having responsive documents was in response to Mr. Hartz's original request.
Okay, I have nothing further on that. Commissioner Kopp?
Chairman, yeah. I support Commissioner Keene's notion of postponing this one more month, reluctantly, because so much time and effort and taxpayer money has been spent on this that it makes me gag. But Commissioner Keene, as usual, is logical. And might I suggest, since you're going to be around as a legislative aide, why not just have one person have every request presented to that person and let that person record it on a simple, whatever you want to call it, chart or whatever it is, the date received, the date by which the documents, if existing, must be provided.
Commissioner Kopp, thank you for the suggestion. And the time since we have changed that process so that I am now the one handling the receipt of all IDRs.
That gives me some comfort.
And it is.
How many requests do you receive a week or a month, whatever period of time you want to use?
I would perhaps 3 to 4 a month. It really depends.
All right, so it isn't overwhelming. All right, if that's a motion, I'll second the motion.
Tell me
I'll put
exactly
it in the
what your
form of a
motion.
motion. I move that we continue.
Oh, I'm so sorry, Commissioners. Before you make any kind of dispositive motion, Mr. Hartz is entitled to 3 minutes of rebuttal.
Okay.
Oh, yeah, I understand that. I wanted.
Oh, there's
I thought
one
you
other
had the
thing
motion,
that-
and then let Mr. Hartz respond to both to that and to the motion.
All right.
Yeah, I'd like a little further clarification also. Sorry, just following up on your.
Well, one thing I'd like somebody can answer, our knowledgeable executive director or our attorney, is didn't this task force make some finding before July of 2015 that the law had been violated?
Yes, I believe the task force made a determination that the law had been violated, but then decided it was a willful violation after Mr. Marr refrained from appearing.
Why did it have to take it up? It makes a determination. It makes a decision. Why would it consider it further? You mean on the second question, whether it was willful or negligent?
I believe they considered it further because Mr. Marr failed to appear at the Education and Training Committee. So what they did was he did not appear for any of the hearings. So they sent it to the Education and Training Committee in order to give him an opportunity to learn how to implement a procedure for responding to IDRs. And when he didn't show up to those hearings either, they changed their finding to willful, I think. But Mr. Hartz,
AKA spinning wheels. Could have been over in
Mr. Hartz,
May
you
or
want to
June.
respond?
Is this my rebuttal or a response? I don't know about you, but if I run an office and I get a request and it falls through the cracks, when I get notification because someone's filed a complaint, first thing I'm going to do is respond to it and get it out of the way. They didn't do that. Then you get a notice of a complaint being filed, and again, they didn't respond to the original IDR. They didn't show up for the hearing or didn't even respond to the complaint. Then they got the notice of hearing, still didn't respond to the IDR, didn't show up for the hearing. Then they had another hearing where they got a letter saying send somebody to the hearing, didn't respond to the IDR, and this just went on for a year and 4 months. I mean, the bottom line is if somebody notifies you, and as I said before, I went before the Board of Supervisors 3 times and put up charts with the names on it of the 3 supervisors who had not responded and publicly notified them. It's all a matter of public record that I sent in this IDR on March 15th of 2015. I have still not gotten a response. The state law is it must be in writing, and got nothing. So going back and looking at what all the task forces ever looked at in any of their hearings is them coming up and saying, we put a procedure in place to deal with this. And now we are here. Supervisor Marr leaves office, so he's going to be gone by the time the next Ethics Commission meeting is held. And the bottom line is his staff is going to be gone, and there's going to be absolutely nothing come of this. And the reality is he knew that he had an obligation to respond to this. He got so much notice, there's no way. He would have to be dumber than a box of rocks to not realize that there was an IDR floating out there that still had not received an answer. And his aides all show up, and I have pity for them because they're caught between the rock and the hard place. The supervisor, for whatever reason, chose not to respond to any of this process, didn't respond to the IDR, didn't respond to the complaint, didn't send anybody to the first hearing, and when they finally did start participating, send people who basically just said, well, we're sorry, this fell through the cracks, and they were repeatedly asked, well, have you responded to Mr. Hartz's original IDR?
Question.
Mr. Hart? Commissioner
How long was it before you got the answer that there are no records?
The letter from Supervisor Marr, that's the answer that I got.
What date was that?
The July 26th
All right, so that
email.
was, what, a year later?
A year and 4 months or 5 months, I believe it was. So basically, it's like, hey, if I make an IDR to the executive director and it falls through the cracks, we're all human. People make mistakes. But if I say to her at the next Ethics Commission meeting, oh, I sent an IDR, and she says, oh, I'll look into it, but she doesn't, and then I send her a letter, and she doesn't, and I send Ms. Bloom a letter, and she refers to the executive director, she doesn't, at what point do you say, oh, wait, he's just ignoring it? He's not responding. He's not even participating in the process. And that's the biggest thing. I did this in a way that there was no way that Supervisor Marr or the other 2 supervisors could stand there and say, I didn't know anything about this.
Mr. Hartz, my question is, what relief do you ask this commission to give you? You pointed out that Supervisor Marr is going to be out of office in January.
6734 reads, willful failure of any elected official, department head, or other managerial city employee to discharge any duties imposed by the ordinance, the Brown Act, or the Public Records Act, which is also, these are violations of the Brown Act, shall be deemed official misconduct. And then it goes on to say that this body will do it. I would like you to find Supervisor Marr guilty of willful misconduct.
And then what? Is there a penalty power attached to that, Ms. Bloom?
No, Your Honor. So the commission has the authority to issue a cease and desist order, to post on its website a finding that the individual has violated the Sunshine Law, whether willfully or not, and issue a warning letter to the respondent. So those are the 3 options. Probably the latter of the 2 is the more appropriate options. But I also wanted to read to you the definition of willful because Commissioner Keene seemed interested in the intent requirement.
Well, I'm also interested in what the evidence was that was before the Sunshine Ordinance Task Force upon which they made the finding. I know what their evidence was in regard to the allegations and Mr. Hartz's evidence that there was a willful violation. I'm totally vague as to what, if anything, was responded to by Supervisor Marr's office at the hearing in which they found a willful violation. And I'm curious, and I'm not just curious, I mean, as we're essentially sitting as an appellate body to uphold the Sunshine Ordinance Task Force willful violation. And in order to do that, I'd like some, if Supervisor Marr didn't do anything, or if his aides just came in and said, we don't know. All right, that's fine. Then I'll know what to do. But so far, I've gotten nothing. Maybe Mr. Hartz will tell me.
What they said was exactly what they've said here today.
Let me fashion it as narrowly as I can so we don't go all over the place. At the hearing on which they found a willful violation, the Sunshine Ordinance Task Force, what was put forward in defense, if anything, by Supervisor Marr's people?
Nothing. What you heard today was exactly the same thing they have repeated at every hearing. This fell through the cracks. We're setting up a procedure, end of story. And when they were asked directly, have you ever responded to Mr. Hartz? The answer was no. And can you give us any reason why there was no response during all of this long, drawn-out process? Their answer was no.
Okay.
Your motion is what?
Well, I'll take Mr. Hartz's representations as being truthful and accurate, that was what the state of the record was before the Sunshine Ordinance Task Force when they made this determination of willful violations. And my motion would be that we sustain the finding of the Sunshine Ordinance Task Force that there was indeed a willful violation.
I hear a second? I'll second. Any discussion?
Before we vote,
But I want to find out if there's any. All right, go ahead, Commissioner Kopp.
I don't get it because I've never seen this task force in action. All I've done is read material about it. But on June 3rd, 2015, there was a decision and order of determination that Mr. Marr violated Section 67.25A for failure to respond to an immediate disclosure request in a timely manner. Shouldn't that have been the end of that part?
They referred him to.
I know what they referred him to develop methods for the future, but they make a finding as to what occurred. What occurred was a failure.
There's no dispute.
So what do they keep going through all this stuff? It goes to a committee which doesn't meet for 7 or 8 months or something.
But he didn't go to the Education and Task Force Committee as he was instructed.
Yeah, but why does he have to be there? If he isn't there, they can dismiss it. You're talking about the complainant, or you're talking about Mr. Marr, or one of his legislative aides.
He, as I understand the sequence, and Mr. Hartz can correct it, is that when they found that he had failed to respond, what they ordered is he should go to the training session to find out how he was supposed to properly respond. Isn't that correct?
Yes and no. That was part of it, but the other part was reply to Mr. Hartz's IDR.
Right.
And he still hadn't. And the one you're actually considering is a second finding, where the first one they said, we're not going to find willful here. We're just going to find you violated the ordinance and tell you to straighten it up. And then a year later, they had another hearing and said, here we are a year later. They still haven't complied with the order. You didn't participate in the process. You know, and you still haven't given us an explanation as to why this never got responded to until July, a year and 4 months later. And at that point, they said unanimously, this is willful. There's just no way we cannot call this willful.
And just for a point of information, Chair, the definition of willful in the Sunshine Ordinance regulations that we've adopted as a commission are: willful violation means an action or failure to act with the knowledge that such an act or failure to act was a violation of the Sunshine Ordinance. So presumably the repeated notifications that the order had been issued to the commissioner or to Supervisor Marr would constitute informing him that that his failure to respond to the IDR was a violation. So he had knowledge that failure to respond to the IDR was a violation and continued to fail to act.
Before I call for a vote, any public comment? Hearing none, I will call all those in favor of the motion to find willful violation. Aye.
Aye.
All those opposed?
Opposed.
No. Let me explain.
Well, let me add.
All right.
Record, the motion did not carry. It was 2-2. All right, Commissioner Cox.
Let me explain my no vote, Mr. Chairman. I mean, it's so much ado here of going through these procedures. The central question is, to me, whether they had documents or not. And that hasn't been examined in this proceeding. It's one thing to say we've got no responsive documents. I don't know. I didn't hear any testimony from Mr. Hartz or anybody else as to whether that was believable or not. Had to do with some grant to the library. But boy, oh boy, a lot of paper and a lot of time of people have been spent on something that should have been handled in the first instance from the supervisor's office, having one person to look at 3 or 4 requests a month, not a very arduous task to perform, and then get a letter or get an email out to whoever requests it. It's
All right, Attorney.
terrible. All right.
Commissioner Hand.
May I comment? All of these referrals from the Sunshine Task Force Ordinance Committee I find very frustrating, because while I believe that a citizen who makes a request of an elected official should be responded to, either yes or no, or we don't have the information that you want. And certainly that can be handled as a bureaucratic matter. You know, get your systems operations in order so that, as Mr. Kopp has stated. But there's also in this particular case, this issue around disclosure around the library. And there have been thousands of requests of this nature to elected officials, to department heads, about this belief that there's something amiss about the San Francisco Friends of the Public Library and their relationship with the library. If there is criminal activity, if there is something of that nature, then the city attorney needs to look into it. I mean, this goes on, and there are also individuals who use this measure, requesting IDRs, as a form, if I may say so, of harassment of elected officials and of department heads. So, I mean, there has to be some happy medium here. Yes, officials need to respond to the public, but if you're bombarding them constantly with stuff, as I think in this case, then it's possible that they may be willful in ignoring these requests. I'm not saying that's right. But really, I mean, as Mr. Kopp has said, look at all this paperwork, and this goes on for months and years, and a lot of it is connected with the Sunshine Task Force. I find this quite frustrating, and I don't really, and if we find the supervisor guilty of official, willfully doing this, and that's official misconduct. That's misconduct. I don't see that. I mean, there's a limit to how much they can do. It should be handled in short order, fine. But there's a sense of frustration among a lot of people who see this going on all the time, and I'm one of those people.
And all they have to do is answer the request.
Fine, and I don't disagree with that. But then it goes on and on and on, and there's something wrong with that process.
And you're trying to cover yourself because you sat on the Library Commission and allowed the same thing to occur.
Oh,
Well, that's a whole other issue. Please, get out of here.
Let's not. All right, I will call item number 6, discussion and possible action on Ethics Commission complaint number 1516-23 and 1516-24, Joel Warne versus Nancy Sarieh and the Sunshine Task Force. Is Mr. Warne here?
Who's supposed to be here? The complainant?
He wants to be.
Apparently not.
Do we have a recommendation from the staff on this?
Yes. And is no one from the Sunshine Ordinance Task Force here?
All right.
Yeah. So the report and recommendation from the staff is essentially the general facts are Mr. Joel Warne was a patient at a hospital, San Francisco General Hospital. After his period of treatment, he requested a number of records of a public information officer at the Department of Health. And that public information officer did not respond in a timely manner to a number of requests. Staff's report and recommendation as to that underlying request is to find that Ms. Sarieh, the public information officer, violated the Sunshine Ordinance and either issue a cease and desist letter or a letter of warning to her and asking her to comply in the future. The more interesting, or perhaps I shouldn't characterize it as more interesting, but the layer on top of all this is that Mr. Warne also filed his complaint against the Public Health Department with the Sunshine Ordinance Task Force, but later withdrew that complaint because the task force did not handle it within the set time frame required under the Sunshine Ordinance itself. So ultimately that sort of blossomed into a complaint that Mr. Warne had against the task force itself. So he withdrew all of his complaints from the task force and filed them with us. And after a review of all the documents and materials and a thorough review of the Sunshine Ordinance Task Force's policies and annual reports over the last several years, our staff concluded that Mr. Warne was correct, that the task force does frequently miss its deadlines as imposed by the Sunshine Ordinance. And so we kind of felt like our hands were tied that, with in the face of such a clear-cut violation, that we should recommend to you that you make a finding that they violated the Sunshine Ordinance and just issue a letter of warning of the 3 options that we discussed earlier: cease and desist letter, public posting on the website, or issue of letter of warning. We felt a letter of warning was appropriate, just advising the task force to continue its efforts to truncate its process and resolve complaints in a timely manner. The task force did respond. Neither Mr. Warne nor Ms. Sarieh responded, but the task force responded, and I think their letter speaks for itself, and I believe that someone else is here from the task force to speak on it as well.
This matter was originally on the
Last month.
November calendar, and at the request of the task force, it was continued because they were unable to, because of the holidays, they were going to be unable to respond. So who is here from the task force, and be happy to hear your response.
If I could just remind the commissioners to speak directly into the microphone so we can record the audio, please.
Pardon me?
If you can speak directly into the microphone.
Oh, I'm sorry.
Thank you.
Good afternoon, Mr. Chair, Commissioners. My name is Bruce Wolf. I'm the incoming chair of the Sunshine Ordinance Task Force, starting in June of 2016. And I will let you know that many other new members to the task force have joined us at that time. So there are at least half, if not more, had not been party to this issue at the time that it commenced. And it had actually, until it started to come through your office, I guess maybe even prior to that. So one thing I can say is there was a period of time where the task force was unable to meet for about 6 months, and it developed a very large backlog. And that was because the Board of Supervisors was unable to appoint a person with a disability. And under the ordinance, there's a requirement that a person with a disability be appointed at all times. So that backlog took a number of years to kind of get settled out. And I imagine there were some times where there were some hiccups that they missed the 45-day rule by a couple of days or so. In this case, it was just 2 days, and not very serious. But it did exceed the 45 days, and we agree with that. And the reason why, just to clarify with a little more detail, we asked for a continuance is because your meeting on this would have happened before the task force had even known about it. And I only found out about it because I get your regular agendas, and I saw it there. And we also had it. It was in the middle of inter office communications between all of us. So I appreciate the continuance, and I should have said that at the beginning. So I just want to further say, so with that, I've instituted to adjust the way we do some things. First of all, the 45-day rule simply is supposed to find whether the information is being requested under 6721 and 6725 only is public. That's all the matter is about. It's not to adjudicate anything. It's not to find any determination, no findings. It's just to make a determination as to whether the information is public. If it isn't public, poof, goes away. Okay? Not in our jurisdiction, per se. We could find that it's public, but not in our jurisdiction. Let's say it comes under HIPAA. HIPAA is not our jurisdiction. So that's what we are determining. So what we've done in adjustment to that is we have pushed all 6721 and 6725, that is regular requests for information and IDRs, to the head of the pack. They go first. They get scheduled first. And so that way we can plan for 45 days in advance. Additionally, what we've done is usually we have 2-hour subcommittee meetings. We've reinstituted the complaint committee in a much more of a full force, where it hears all complaints. And if there are any overflows, they go to any of the subcommittees. But we're using the second hour of any subcommittee to start a complaint committee. So that way we can have more than one within a 45-day period if we start to see that they're beginning to pile up. So those are the adjustments that we've made for ourselves. And with that, you can answer any questions.
Do you have any?
And also, we have Victor Young here, who is our administrator. He has more detail about this particular case because I wasn't party to it.
No.
Do you have any objection to the commission issuing the letter just documenting the determination that in the past you did and warning you that try and comply?
This iteration has no problem with that.
Has no what?
Has no problem.
Yeah.
If you find a violation, we have no problem. We'll own up to it. We get a pretty heavy caseload. But
may I ask?
Yes,
is Mr. Warner here? The complainant is not.
No.
Do we have a rule or a policy if a complainant isn't interested enough to show up? It's a sign to me that he doesn't want to pursue it. Notwithstanding Mr. Wolf's acquiescence in what to me would be a superfluous letter after listening to his testimony, and the fact that the complainant doesn't seem interested.
I don't think there's a requirement under our rules. We give them notice.
I know he's given notice right here.
There isn't a requirement that they have to appear.
That's correct.
In other words, he could rely, the complainant theoretically can rely on the record that was made that brought it here. Anyway.
Yeah. All right. I mean, to me, it's a fiction to send a warning letter after this testimony.
We'll accept whatever your wisdom provides.
All right, do I hear a motion?
I move we send the letter.
In other words, accept the recommendation of the staff?
Yes. Send the letter.
Do I hear a second? All right. Any public discussion?
I just want to clarify, are you finding a violation or are you sending a letter?
We're finding a violation.
Finding a violation
Very
and
good.
sending the letter.
Very good. Just wanted to hear it. Thank you.
All right. Any public comment?
Commissioners, Ray Hartz, Director, San Francisco Open Government. As you know, I have spent years going to the task force meetings. I have 30 orders of determination, not one of which has been enforced, not one. And the law itself says that this Ethics Commission is responsible for enforcing it. And I think it's rather ludicrous that every single order of determination but one forever, ever, has been found to be the Sunshine Ordinance Task Force got it wrong. And here you are sending a letter of condemnation to the task force when they have a case before you that is 2 days past the 45-day deadline. You are responsible for enforcing this ordinance, and you have never enforced it ever, ever, ever. You tried one time. You sent a letter to the mayor unanimously recommending the former commissioner, the president of the Library Commission, to be removed. He ignored you. A year later, we shamed the commission into sending it again, and he ignored that. And I've said this before, and you don't like it, but the bottom line is I think you just do this so that you can avoid trying to enforce it because you have no power to enforce it. And you don't want that to be obvious to the public. Either no power or no will. I've got 30. That's just me. There has never been an order of determination sent to this body where you've done anything except one time. Now tell me whether any reasonable person would say that that was logical. That you get it right every single damn time, and the task force never gets it right ever, but once. You don't want to enforce this. Why? Because you can't. The one you did try to enforce is sent to the mayor, and the mayor ignored you. He ignored the letter you sent a year later. And so bottom line, you sit there and say, well, we're not going to find a violation because if we find a violation and we send it to somebody like Supervisor Marr, who you sent it to? The Board of Supervisors. What's the Board of Supervisors going to do with it? Nothing. They're going to ignore it, just like the mayor ignored your one related to the Library Commission. So the question is, who are you being honest with? Yourselves? I don't even think that. You're not being honest with the public, that's for sure, because all these years, the law clearly says this body is responsible, and I find it incredible, unbelievable, that there has never been a single one, except that one time, that has come here that you didn't sustain it. What does that say about your credibility?
Thank you. Any other public comment?
Question, Mr. Chairman. I don't recall, but does the Ethics Commission have the power to order the mayor to fire a department head?
No. You can if there's a finding of official misconduct, a willful violation of the Sunshine Ordinance, it just gets referred to the mayor, but it's up to the mayor what they want to do.
We could recommend that, in our opinion, the person should be fired.
Yeah. Okay.
I will call the question. All in favor of the motion? Aye.
Aye.
Any opposed?
Oh, this is on the admonition.
On the letter.
All right.
Yes.
All right. Aye.
All right. Anybody opposed? Hearing none, the motion is carried 4-0. And it might be some thought for future meeting, that maybe the enforcement mechanism should contain some financial penalty as opposed to simply a letter. But that would require legislative action in order to accomplish
that would be logical.
Well, but that would require a changing of the Sunshine Ordinance statute, which provides for what in the Ethics Commission power. But that we can put that on the agenda for a future date. All right, turning to item number 7, discussion for enforcement report and update. And Ms. Bloom, I will call on you.
Yes, thank you, Chair. So in the tradition of our new enforcement reports that we give you every month, I just provide program and operational highlights. As you have no doubt read already, I'll just summarize for you verbally. We went to the Council on Governmental Ethics Lawyers Conference in New Orleans just last week. It was an absolutely delightful time. I learned a lot, and I really appreciate the opportunity to go. So thank you. In addition to that, we've also been reviewing the older complaints that we have in the files and getting probable cause reports sort of in short order ready so that we can present some to the Commission in January. I've been working on several stipulated orders with folks for disclaimer violations, and then also preparing now for a hearing on the merits that we'll have in January. Because no one on staff is licensed under the California Bar, that hearing on the merits will be presented by hopefully someone from the Oakland Ethics Commission. They tentatively committed to that for us, so you'll have basically a guest lawyer come. In addition, we continue to intake several complaints. The complaints have sort of tapered off a little bit since the election, but in the last couple of weeks of the election, in the last couple of weeks of October and into November, we received a number of complaints. You'll note that our intake in the last 0 to 3 months is at 36%, which is 36% of the overall complaint load, which is quite a lot. And in that time, we lost our only investigator. So we're doing our best to try and triage those complaints as they come in. Staff has been very helpful in sort of filling those gaps and working with me on getting those managed and tracked correctly. And we do the best that we can. But for now, our priority has been really to get rid of those older matters so that we're at least under 18 months when our new staff come on board. And with that, I'll answer any questions you might have about the charts or anything else that have been provided in the report.
Any questions or comments? Commissioner Kopp?
On page 2, the chart, which I welcome, but on 4 of the 5 items, there's no notation as to status, and at least 2 of them are going on 20 months old.
Yes. I believe that I had told you at our last meeting I would get you a document from BDR, something that explains their process, and I forgot, and I will follow up on that this time. I do know that the Lynette Sweet matter will go to BDR on the 90th day after the order was issued by the Commission, and so that will be later in December because the Commission issued its order in September. So in January you will see Lynette Sweet on here because she is not paid.
All right. And then going to the first one, we're looking at a year-old judgment. Do we ever get, or do we ask for a report on what's been done to enforce the judgment?
We do ask, and on this one we actually have because we had some inquiries, external inquiries about it. This judgment, I mean, the BDR has attempted to execute on the judgment by filing it with the court and doing like an asset search, but they still have not obtained any money from Mr. Jackson. The court's investigation turned up no assets in the city of San Francisco, so they can't. There's nothing to attach the judgment to because he doesn't have anything in the city and county.
Execute, not attach.
Right.
Can you write them and ask them if they've conducted an order of examination of the defendant?
That I don't know. I can ask them that.
Would you please?
Yes.
And you can attribute the request to me. Thank you, Mr. Chairman.
All right, any public comment on item number 7? Hearing none, we'll move to item number 8. Thank you very much, Ms. Bloom. Very helpful. Item number 8 is the Executive Director's report.
Yes.
Ellen?
Chair Rennie, thank you. I have first a series of highlights, but the most important, I wanted to introduce you to one of our new staff members. Jacqueline Hickey started with our office on December the 12th. I believe she's here this afternoon.
Welcome.
She's our new senior clerk. She will be the front face of the commission to those who are calling us and coming into our offices. She joins our education and compliance team, working with Pat Peterson, Jared Flores, and also Johnny Hosey. So we're very delighted that Jackie's here. Johnny Hosey is also, we have good news to report. He assumed the role of our education and compliance assistant after a competitive recruitment, effective December the 7th. Johnny has been in our office for the last 2+ years as a special projects assistant, and he'll be now helping provide a deeper level of support to the public on questions that come our way and filing assistance. And so we're delighted to have that announcement to share with you as well. As Johnny moves along, we are lucky to have the benefit of our 2 as-needed staff people for a bit longer. They'll be here. Francis McAvoy will be with us for much of this into the spring as a full-time staff assistant, filling Johnny's place until she moves on to her stint in the Peace Corps this coming spring. And then Jack Canis will also be able to stay with us for another month, providing continuity and transition as Jackie joins us. So there has been some developments on that front. Also, we've continued to have as a very top priority of my time and a number of others, working with the Department of Human Resources on the 8 pending positions that we have under recruitment. There are still 8 vacancies, and we are effective today, have a work order that is initiating a full-time senior personnel analyst to support our department solely to help get these recruitments and hirings through the process. As you know, it is a very intensive hiring process, and we want to make sure we get it right. We're delighted that we're able to have this additional set of eyes and experience working with us over the next 6 months. So I look forward to having more to report to you in January as that process moves along. And I don't know... we met with Doris Lorio this morning. She was possibly going to be here to be introduced as well, but you'll be hearing more in January on that front. Separately, in terms of policy and legislative developments, attached to this report is an updated policy plan for this month. I realized there was one oversight that I needed to include the Commission's development of an enforcement policy with regard to investigative work following notice to the district attorney's office. That's something that we'll have for I think, including in the January agenda, if we can bring that forward to you. But that did not show up on this month's update, so I apologize for that oversight. Separately, the whistleblower protection ordinance I wanted to bring back to your attention. That is something that the Commission obviously weighed in on earlier this year. Following introduction of the ordinance, amended ordinance by Board Supervisor President London Breed, the staff from the Department of Human Resources, the Controller's Office, and our office have been continuing to meet to discuss in-depth implementation issues around the whistleblower ordinance. Following those conversations, we've had a series of recommendations that are likely to come forward that we believe continue to still squarely meet the goals of the whistleblower ordinance as the Commission envisioned it, and also to make sure that it's strong when it comes to implementation. So I wanted to just highlight some of those key changes through Jessica for a moment, but we anticipate that it'll be in early January that this will come back to the full board. But we wanted to make sure you were aware of some of these changes as they were going through and being recommended. Let me turn it to Jessica for just a moment.
Thanks. So we realized quickly after sending this over to the Board of Supervisors that there was some collaboration that needed to happen between some other departments, one of which is the Controller's Office and the other is the Department of Human Resources, predominantly because the Controller's Office is the entity that investigates whistleblower complaints unless they have something to the complaints are within our subject matter jurisdiction. And then the Department of Human Resources has a lot to say about retaliation, because they're the ones who work with the unions and Civil Service Commission in order to actually do the reinstatement if that is something that the Commission desires to happen. So, working with those two agencies, we've had a series of very productive meetings. We've identified 4 key areas that sort of were sticking points for everybody that we needed to work through. The first is training and intake. So the concern really is the Commission's original whistleblower ordinance expansion would have expanded the intake of whistleblower complaints to all local, state, and federal agencies with authority to intake those complaints. The Department of Human Resources and the Comptroller's Office both, I think, were rightly concerned that the Commission wouldn't have authority over state and federal agencies if they failed to act on those whistleblower complaints, and wouldn't have authority to recapture any evidence that might have gone to those agencies had someone whistleblown to them. And so, as a practical matter, they both desired that the authority to intake whistleblower complaints that affect the city happen only at the city level. They further wanted to see us only allow intake of complaints to supervisors. The way that we initially drafted this ordinance and sent it to the board, intake of complaints could have happened across any number of employees in city government. And the theory was that, like, say, a janitor or an outcry to a colleague shouldn't engender the same level of protection as a properly reported complaint to a supervisor. We felt that was a good compromise to make, simply because in so doing we expanded the number of places where a complaint can be filed by 3,000. So, or was it 8,000? I think it was 8,000. So it went from a handful of departments to 8,000 supervisory employees, and the Department of Human Resources and Comptroller's Office are on board with that. So with that intake comes some training requirements, because none of those supervisors right now are equipped to take those complaints in or handle them. So our whistleblower ordinance now requires mandatory training of supervisory employees on how to intake whistleblower complaints. And that Comptroller's Office is very excited about that. And so they actually provide the language that we used in order to make that a change to the whistleblower ordinance. So in terms of now we've got 8,000 more places to intake complaints. We're going to train our supervisors. So the question is, what types of complaints should whistleblower retaliation protection attach to? And in evaluating that aspect of the ordinance, we really had a breakthrough moment, and we saw that the whistleblower complaints themselves can be filed with the Comptroller's Office either originally or through these supervisors without really necessarily meaning that the filing of that complaint with the whistleblower was the only way for someone to get retaliation protections. So a good hypothetical to sort of understand this is, under the current regime, if you reported your complaint of retaliation to a supervisor, the Ethics Commission could not do anything about that, because the complaint under the law has to be reported to the Comptroller's Office whistleblower program. This commission rightly wanted to expand that, because that's nonsensical. If somebody is retaliated against for reporting a concern to a supervisor, they should get protection from that retaliation by this commission. So what we did was we bifurcated the protection of whistleblowers from the place where they filed the complaint. So if you want a complaint investigated by professionals for fraud or improper government activity, you file your complaint with the whistleblower office. If you are retaliated against for filing a complaint either with the whistleblower office or with your supervisor or with your department head, you file those complaints with the Ethics Commission, and we can investigate and protect you no matter where you filed that complaint. So we separated the two processes for all practical purposes. In doing that, we had to develop some new definitions. So we improved the definition for improper government activity to include circumstances of fraud and waste. We included unlawful activity, which applies to government contractors, to include fraud and waste and some other aspects. And then we actually included a definition for fraud and waste. The civil grand jury asked us to include gross fraud, waste, and abuse. we decided to use, in conjunction with the Controller's Office, the terms that are in the whistleblower ordinance itself. And I can read those terms to you. The terms are misuse of city funds, improper activities by city officers, deficiencies in the quality and delivery of government services, and wasteful and inefficient city government practices. So rather than adopt new terminology, we just stuck with the terminology that's in the existing ordinance. So those are the ways that we sort of collaborated with the Controller and the Department of Human Resources to improve this ordinance in a way that we think will be really effective going forward in terms of differentiating authority and enforcement of the various protections.
Any questions either of the director or Ms. Bloom?
My question is, who knows logically why this power was reposed in the controller of all officials? There's no nexus to it.
Could have been Sam Duca doing it.
Beg pardon?
Could have been Sam Duca doing it at
Yeah.
one point. Yeah. Historically, people probably will have no idea.
No,
what
they
I'm
don't
talking
know
about,
that reference.
Commissioner Cobb,
But seriously, it ought to be in the Ethics Commission.
Well, as I understand it, the administration of the whistleblower hotline originally was when the Ethics Commission was created, but that at some point in the late 90s, the program was changed. The administration of the whistleblower hotline was changed to the Controller's Office, and that may be a bit of history we have to do some research on. I don't have that at the top
We ought
of
to ask our leaders to re-examine that, get it back here.
And if I might, Commissioners, two other key things to highlight for you. First is to, without a lot of fanfare, that we're very excited to announce that we have posted today notice of web maintenance that will be occurring on Wednesday. The translation of that is that we anticipate rolling out our new website this week. And so we are doing what we can to notify those who might be working with our site, noting that this is hopefully a quiet week where there are no filings due, that we'll be able to have people start seeing that site beginning Thursday. So we are communicating with folks who may be affected by this. As I said, it's a soft launch. We are very much looking forward to engaging the public more broadly through our senior fellow. It is a work in progress on a continuous improvement as we go forward. But I think our goal of really making this a much more navigable site, much more user-focused site, and the ability to build better tools to help people comply and understand the laws is something that we're really excited about. So if you see any glitches this week, we will be in maintenance mode. Hopefully we will be up on Thursday, and we will look forward to bringing a report to you, demonstration at the January meeting with our senior Fuse fellow, Gayatri Taikandil, who's been working very closely with Stephen Massey and the rest of the staff. So our fingers are crossed for that. We appreciate everybody's patience as that plays out this week. And then finally, budget developments. You've probably all seen news in the press recently. The mayor has issued his instructions to departments for the coming fiscal year's budget. Earlier this month, we met with a new budget analyst who's been assigned to our office from the mayor's office, Nareda Heller, who I believe is still here in the back of the room. So we did a briefing about our operations and our programs and priorities. And the mayor met with department heads on December the 8th to walk through his instructions regarding the submission of the budget for the coming couple of years. You'll recall that we submitted a 2-year budget last year outlining our priorities and focus. But because we are not in a fixed 2-year budget process, we will be submitting again documents to the mayor's office in February. The deadline this year, I believe, is February 21st. So my goal is to have to you in January a document that speaks to the Commission's budget for the next couple of years. The mayor addressed a post-election rebalancing plan, cited concerns about a 5-year projections, and basically has said to departments that we are not in layoff mode, we are not in cutting services, but that we will be, as a city, his goal is to take steps to rebalance in light of slowing economic indicators. What that specifically means is that departments are being asked to not grow their budgeted and funded full-time equivalency or headcount. So we are being asked, as all departments are, to propose a 3% cut in the next year, as well as a 6% cut the following year. And that's out of a base budget of roughly $3.3 million, which would, if it were in place for us, translate to a cut of 2 people from our currently funded and authorized list. All that said, all indications are, as you know, it's a critical priority for us to right-size our organization and to see the hiring through that we launched this year, and we have been doing that and will continue to do that. It's my understanding and hope that because the mayor's office saw this as a priority for us as well, and that the budget embraced that as a priority for us, that we will continue to move forward so that we can do the important work that we have in front of us. But I wanted to highlight that for you. That is the update from the mayor's office. Nareda is here if you have any particular questions for her. And I'm happy to answer any questions.
Do you want to give us some further information beyond what Ms. Pelham has told us? Sure. And we appreciate your patience in staying.
Yes, thank you. My name is Nareda Heller. I'm joined by my colleague, Ted Conrad. I don't have any comments to add really to what Leanne has told you. We are asking for no net additional FTEs to be added, but that does not mean that any of the positions approved for 17-18 in the previous budget season should be cut. All of those positions are safe. The 3% cut is obviously something we're asking every department to propose options for. And my supervisor, Melissa Whitehouse, the budget director, has asked that not be from layoffs. There's no request for hiring to slow down. There's not a hiring freeze in place. And we do understand that the Ethics Commission is understaffed currently. So hopefully these cuts can come from somewhere that is not FTEs. And if no efficiencies can be found, we're very willing to meet with the Ethics Commission and talk about what can be done.
I think I speak for the Commission when I say that we were very strong in urging the mayor to adopt the budget that the executive director had submitted. He was kind enough to acquiesce and give us some extra positions that we sorely need. Mm-hmm. And hopefully you'll carry back the message that we still feel strongly that in order for this commission to be effective, the budget that was submitted in 2016, certainly and hopefully implemented in 2017, would stay in place in spite of the city's concerns. Okay?
Yes, and the positions that were approved in this year's budget season for 17-18 should not have to change.
Right. Commissioner Keene?
I just want to emphasize what Chair Rennie said in regard to the budget that we have now. When originally we had the mayor's instructions for this 2-year budget, there was a request from the mayor that we outline what I think a 2%, 3%, 6% kinds of cuts. And one of the things that we all felt strongly about were, in terms of the history of the commission, was that we have a new executive director, excellent executive director, who's very vigorous in terms of what we need. The history of this commission, though, in terms of the previous executive director, was not that. And he was not someone who advocated on behalf of the budget. He just sort of went along with any cuts. Even during years when the city was very flush and other departments were getting things, he never asked for a thing. And from what I could see, the only thing he was concerned with was whether or not his position was being downgraded or cut. If that didn't happen, everything was fine. And the commission has been acting for a number of years in regard to with a lot of problems because of that, because of there being no vigorous advocacy on behalf of the budget for this department as there is in regard to so many other departments. I was the chief assistant public defender for 20 years and advocated very strongly on behalf of our budget when I was, as does every budget director or that I've ever seen or dealt with in my history with the city, with the exception of the previous executive director of this commission. So one of the things that we had done in order to sort of highlight our our real strong feeling about this is we instructed Ms. Pelham to not submit the last time any proposal that in regard to a 2% or a 3% or 6%, and she didn't. And the mayor, we were very pleased when the mayor came back and gave us the positions that we had asked for, which should have been there for years and years and years. So I just would like to have you and the mayor's office continue to have this historical emphasis that we have, that in terms of what this commission does in relation to the ethics of San Francisco city government is extremely important to the citizens of San Francisco. And it can't be sort of looked at and played around with as it doesn't exist, so I can use it, the dog catcher's department or whatever else there may be. We believe that we're on a different level than that, not just in terms of what we do, but in terms of the history of the fact that this commission has been so ill-served in regard to getting its budget to the point where it needs it. Okay, so I just wanted to send that message.
Thank you.
Right.
Thank you. Any other? Okay. Thank
All
you.
right, thank you very much.
And just lastly, I want to echo Jessica's comment at the Kogel Conference, Council on Governmental Ethics Laws, 38th Annual Conference in New Orleans. It was an extraordinary opportunity to get to sessions that talked about a lot of topics that are very close to the work that we do. And I think we're both digesting it and looking forward to sharing that with our colleagues on the staff and certainly with you as you're interested in. There was also an opportunity for us to be in touch directly with our peers from around California, both in the state levels and local agencies. And I think that continues to spark a lot of good collaborative work, looking at each other's best practices, and also to connect with people who will be of use and of interest to you all as we go towards a policy summit and really crafting the most innovative and important reforms we can for San Francisco. There are a lot of good people very much realizing that a lot of the action is happening most effectively at the state and local level, particularly at the local level. So we're looking forward to drawing on the lessons from our colleagues and to really shape a good year coming up for you. And with that, just from all of us on the staff, want to wish you and the public who engages us so regularly and robustly a very happy holiday season.
Thank you. Any public comment?
Chair Rennie, members of the Commission, a couple of points. First, on the whistleblower discussion that just took place, I would urge that the Commission ask for an interested persons meeting before there's any final action that comes from ethics or any concurrence from ethics staff to President Breed. I see that we were just informed that there is an objection to having complaints go to all agencies, but should just go to city agencies. I worked for 15 years for the Department of Housing and Urban Development. We received many complaints from people who were facing retaliation for bringing up complaints on HUD-funded programs. And I think it's appropriate that at a minimum that the city inform other agencies when there's a relationship between those agencies and the city that a complaint has come in so that the other agency can take action if necessary. That would include the HUD Inspector General, Department of Transportation Inspector General, any of the others. They should all be informed when something's going on. It also was a suggestion that only supervisors would be getting the training, but in fact it's supervisors who are the ones who do the retaliation. And you can imagine what it's like for an employee to sit there and be told by a supervisor, here are your rights, and then suddenly, by the way, you have a right to file a complaint against me. That doesn't work. And it also is shown not to work. And in the controller's own report on the whistleblower, when they look at the national standard, San Francisco is far lower than other jurisdictions in the number of complaints that are filed and resolved. And one of the reasons is because other jurisdictions do training for all employees, not just supervisors. The issue of record retention is important because right now, as you saw with Steve Kawa and some of the other cases, there is an ability to destroy records even in the process of having an investigation underway. There should be a policy that should be saying that the records have to be retained during the period that an investigation is underway. There should also be a clarification that misconduct includes such things as sex harassment, where we have seen that taking place in the workplace, or bullying or other kinds of threats. The policy should include agencies like the San Francisco Housing Authority that generally has not been included in the past. I was involved in the creation of the whistleblower program when Mayor Agnos was the mayor. It was assigned under the mayor's office. The first whistleblower was a fellow named Ed Lee. He came and talked to the Ethics Commission about how the Ethics Commission and the whistleblower could work together. After a period of time when it was clear that the Ethics Commission was going to do nothing, Ed Harrington, as the controller, suggested that it be transferred over to the controller's office, and that's how it ended up in the controller's office. There's no reason not to bring it back here. It was in the charter here. I know my time is out, but I have two other things I really like to mention.
Move.
Go ahead.
2 minutes.
On the budget, I'm glad to hear that they're not planning any changes, but San Francisco fines and penalties that are paid at the direction of ethics go into the general fund and are not looked at as part of the city of the ethics budget. But I looked at in the current calendar year, the Ethics Commission has leveled $119,059 in fines. That's not late penalties or anything else. That's in direct fines. That compares to the $103,000 that they're asking. So there is some reciprocity that looks like it should be appropriate. And finally, when you're taking a look at enforcement issues, I hope that you take a look at the Police Officers Association's current campaign asking the public to contact the Police Commission over the use of force policy, which they're doing with television ads. That would certainly appear on its face to be an expenditure lobbying effort that's not reported as expenditure lobbying. So as you review how things are working, you might use that as an example of whether or not all of the expenditure lobbying is being disclosed as it should be. Thank you.
Thank you. Mr. Hartz.
Commissioners, Ray Hartz, Director, San Francisco Open Government. First, I'd like to address Commissioner Keene's comment on the budget. That did not occur in a vacuum. I agree with you that the prior executive director was very lax, but both Chair Rennie and Commissioner Hayon were on the Ethics Commission during that entire period, and to the best of my knowledge, they made no effort whatsoever to get any increase in the budget. Mr. St. Croix was the executive director, but again, he was not working in a vacuum. He did that with the acquiescence of the Ethics Commission. So if the budget was bad, it was the Ethics Commission's fault. You can try to pin it all on Mr. St. Croix, and believe me, I'm not a defender of his, but don't try to wave off your own responsibility. Secondly, on the whistleblower program, I feel a little prescient because I recently did file 2 complaints with the whistleblower program, one against the city library regarding to the Friends and Foundation, which they are currently investigating, and a second one against Sue Blackman, the Library Commission Secretary, for basically allowing her personal feelings to interfere in her responses in her public duties. In her public responses to public records requests now, and despite which Commissioner Hayon, I don't know where she got her thousands of numbers, I maybe do 1 or 2 in a month. And she has started to put in things where she has stated publicly in the public record that I am waging a vendetta, I am harassing them, and then she started to put in comments about how she didn't like the tone of my voice, the words that I use, and etc. So basically, she has started to publicly slander me in writing, libeling me, in retaliation for the fact that I file complaints which are lawful complaints, or I file public records requests which are lawful requests. And she and the Library Commission and the library have been found in violation 7 times. So where you got the information, that where Commissioner Hayon got the information that there are thousands of requests, either somebody's lying to her or she's making it up. There are not thousands of requests. 1 or 2 a month is not thousands. And as you heard earlier from Supervisor Marr's representative, when the Commissioner Kopp asked her, how many do you get? She said 3 a week.
No, a month.
Three a month, thank you.
3 or 4.
It is not what they always claim. Oh, we get thousands of complaints and we can never do anything else but except respond to the complaints. We get thousands of requests for documents and we can never respond to the documents. It's all bullshit. Excuse my French, but that's bottom line. That's what it is.
I won't excuse it.
Well, you don't have to, Judge. You know that. The Constitution says I can use whatever terms are appropriate if I feel they're appropriate.
Well, I don't have to listen to it.
And do I get extra time since he interrupted me?
Your 3 minutes are up.
Okay. Stand by for next year.
Thank you.
Every meeting, beginning and end.
Any other public comment? All right, let's turn to item number 9, was the discussion and possible action regarding complaints received or initiated by the Ethics Commission.
Oh, wait a moment. Before we go there, Mr. Chairman, on the Executive Director's report, I think we should note the election of Ms. Pelham to the Governing Board of the Council on Governmental Ethics Laws Conference. Congratulations. An auspicious achievement, I'm sure.
I think we all join in that. That's awesome. All right, turn to agenda item 9, which is a discussion, possible action regarding complaints received or initiated by the Ethics Commission concerning San Francisco Campaign and Governmental Code Section 1.22, paren B, close paren 1, close paren, prohibition using funds raised by a candidate-controlled committee for purposes other than the candidate's campaign in possible closed session. I'll call for public comment on item 9 before we vote on whether or not to go into closed session.
Chair Rennie, members of the Commission, I'm Larry Bush. I've sent to the members of the Commission some material that I think is relevant to cases like this, though I don't know the specific case that you have before you. But I hope that you'll have an opportunity to review that and take that into consideration in this or any other future case. Thank you.
Thank you. Mr. Hartz, do you want to make comment that you wanted to make earlier when your time ran out?
That's not germane to this agenda item. It's a violation of the ordinance, and I wouldn't do it.
All right. Thank you. All right. Do I hear a motion to whether or not we should go into closed session on item number 9?
I would just say that it's required by the charter to go into closed session.
Then why do we need a motion?
It's a procedural anomaly that it has to occur in closed session, but nonetheless, there's a motion that's always required to go into closed session.
All right.
So moved.
By order of the chair.
I'll second the motion.
All right. All in favor?
Aye.
Opposed? All right. We will now go into closed session, and I would anticipate that we probably will come back into public session by 3:45. And we'll take a 5-minute break before we go into closed session.
Right.
SF Gov TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television.
All right, we are now back in open session, and do I need to have a motion as to what shall be disclosed, although we've already dealt with that in closed session?
No, I think you already made the motion as to what to disclose, and so now it's up to you to disclose what you decided to disclose.
Then, in closed session, the commission agreed to a stipulation, decision, and order in the matter of Stuart Shuffman, Stuart Shuffman for Mayor 2015, complaint number 29-151-1023, and the full stipulation and order will be on the Commission's website probably by tomorrow. All right. Turning to item number 10, discussion and possible action on items for future meetings. Any commissioners have any comment or discussion?
Well, Mr. Chairman, I would like calendared with certainty for our next meeting the matter of existing complaints and the status of existing complaints, which probably requires a closed session, noting without reference to any specific complaint that there are approximately 30, and some have occurred, as would be expected, since the election or just prior to the election. But we've got about 10 that have been abated at the request of the district attorney going back as far as almost 2 years ago. Justice delayed is justice denied. And there are also, I think, 3 that were abated at the request of the city attorney. And I want to know the status of those, and I want to know why the status is whatever it is in each of those matters. It is, to use the cliche word, troubling. And most of it is probably due to the lassitude of the prior administration of the commission staff. That's my request.
All right. For the record, I have asked the executive director to have a item on the agenda every month, which will be a closed session item, to discuss and get a report on all outstanding complaints and their status, and that will be recurring every month, so that the public understands that it is done for the purpose that was expressed by Commissioner Kopp, that that cases don't fall by the wayside because no action was taken, having been referred to the DA or to the city attorney or to some other agency, and then the statute of limitations run, for example. But we will do this on a monthly basis to be sure that we're on top of pending complaints. Any public discussion on that and on any other item that you wish to discuss?
To make it very clear, Ray Hartz, Director, San Francisco Open Government. I follow the Sunshine Ordinance, the Brown Act, and the California Public Records Act. I make my requests in accordance with those laws, and I expect that the responses will also be in accordance with those laws. So I will talk about this agenda item specifically. First, I think it's a very good idea because a lot of these things in the past here and at the Sunshine Task Force did fall through the cracks. Earlier in my case, Commissioner Kopp seemed concerned about the fact that this case concerning Supervisor Marr dragged on for 14 months, and somehow that became my fault. Supervisor Marr didn't do his duty. He was responsible for responding. He failed to do so, and I have to believe that he didn't handle much of that himself. He directed his aides to ignore the hearing, not to go to the hearing, not to attend. I find it kind of ridiculous to believe that his aides wouldn't have told him that there was a hearing or so forth. And so the reason it dragged on for 14 months, and I'd get up my list and show you my 30 orders, I'll tell you those 30 orders, not once has anybody ever picked up a phone or sent me an email and said, we weren't aware that you had an IDR. We lost it. Could you send us another copy and we'll be glad to do it? Every single time they forced me to go through the entire series. That case was 16 months. And none of that was my fault. In the Navy, we used to call that blame the victim. Somebody doesn't do their job, and instead of holding them responsible, you blame the person that they committed the act or the violation against. As far as having a schedule of items, there was something else I was going to talk about, and I can't remember. Oh, future actions. As much as you dislike me coming here and ranting and raving or whatever, you know, bottom line, after 8 years of doing this, I've realized the spoonful of honey doesn't work. You don't even get a response, let alone an action. So if you can't get a response, you go for a reaction. And again, that's blame the victim. If someone keeps coming back again and again and again and raises an issue and you simply refuse to even address it, don't be surprised if they get a little frustrated. I mean, think about it. I see the law that says this body is responsible for enforcing the Sunshine Ordinance. I have 30 orders, and you won't enforce any of them. You won't enforce them, not just for me, for any citizen of San Francisco. If they go to a public meeting and they're told they can't speak, and they get an order and go through all the trial and tribulation of getting one, you simply ignore it. And you expect that people are just going to be nice and calm and go, oh, okay.
Thank you. Any other public comments?
Just so the record's clear, I didn't blame this gentleman for that, whatever it was, the Eric Martyr case. But apparently anything anybody utters on the commission reflects blame on him. All right.
Right. Well, before asking for a vote on adjournment, I want to wish everybody a Merry Christmas, Happy New Year, and all right. Take your public comment before I wish Merry Christmas and Happy New Year.
Ray Hartz, Director, San Francisco Open Government. At Commissioner Kopp's first meeting, he was kind of offended because I got up at each and every agenda item and made comments, and he didn't like the comments and whatever. And I think you, especially those of you who are attorneys, know that the fact that you don't like somebody's comment isn't a reason to tell them they can't make it or disparage them. And that's what you do. You make it, instead of having a honest discussion with someone, you make a little sly remark that kind of, you know, oh, well, everything that we say, you know, he takes it personal. Well, you know, the bottom line is, yes, I take it personally. I'm the one who had to sit through 60 hearings to get those 30 orders of determination. And I'm the one who has come here for years and said, why won't you enforce these? And have been ignored. I've put in complaints and had those complaints. I've been even denied a hearing. And you ask why, and well, that's confidential. So, you know, it was kind of interesting when the executive director, after that first meeting, the executive director and Ms. Bloom were showing signs that, hey, this is, you know, really changing. I came in the next time in October, and my comments were very temperate, I think. And in November, I looked at the agenda and I decided, well, you know, nothing really here particularly that I want to comment on, so I'll just let it go. And I only came tonight, and I was going to leave after my hearing because I figured, you know, hey, it's pretty much a slam dunk. He broke the law. There's no question about it. He violated his duty under the ordinance. And, you know, it's kind of like, oh, okay. So what we'll do is starting next year, I will be here every session, and I will use the language I want. And if your sensibilities are such that someone needs to walk out of the room, because I used a term, which incidentally, Malia Cohen, a supervisor in the Board of Supervisors meeting, used that very term, and nobody seemed to get upset there. And in a public meeting, she also referred to a member of the public as an asshole. So if members of the public...
I don't tolerate vulgarity in a public place or in a private. Finish your 3 minutes without me.
It would seem that Judge Kopp has never heard a dirty word. And the fact that he doesn't like the word, he knows as a matter of law, you aren't allowed to stop someone from saying it. And very frankly, I don't really care about your sensibilities because you have shown time and time again you don't care about mine. I can come here with a legitimate grievance, raise a legitimate issue, use all the polite terms that I can, and I will be ignored. And that's something I've learned from a lot of them, especially the Library Commission. And if that's what it takes, that's what it takes. If you don't like it, TS.
Thank you, and Merry Christmas to all, and Happy New Year. And do I hear a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
Aye. Opposed? Aye. Meeting adjourned.